Hi, today I'd like to talk to you about the difference between a will and a trust. I get this asked often because it's confusing. Which one do I need? Do I need both? And what are the differences between the two? Let's start with the similarities first. Basically, both of these are types of documents that you can create. A will and a trust are simply written instructions that you're leaving behind for other people to carry out so that they know what needs to be done in certain situations. At a basic level, that's what they both are. However, they're vastly different in their execution, and they're vastly different in what situations they apply to. So let's start with a will. A will deals with a specific situation, your death, and they are written instructions where you're indicating what you want to have happen to your things, your assets, your body, and your minor children, which are all things you can include in a will after you've passed away. And you left those instructions to people commonly known as executors. Here in California, we call them personal representatives. A will in California has to go through the probate process. If your assets are above a fair market value of $166,250. If they're below that, then it can go through what we call a small estate or informal probate. Most people, however, in California are going to be above that mark, particularly if you're homeowners. And so if you leave written instructions in a will, then your estate is going to go through a probate process. And that can be problematic. You can watch some of my other videos where I talk about the perils of probate, but basically what you're leaving behind is time delays, court supervision, costly fees, and more of a headache, even when you're leaving written instructions. A trust, on the other hand, is a written document that is more comprehensive and inclusive of a variety of different circumstances that could happen to you both in life and in death. Whereas a will just deals with you dying, a trust can deal with a situation where you're still alive, but you may be temporarily or permanently incapacitated. It also allows you to build in provisions that concern your trustees or your beneficiaries, your trustees being the people that are in charge of your trust, including yourself or others later, and your beneficiaries, people you're trying to give benefit to either in your life and your death, over certain situations in regards to them that you either can foresee or you don't foresee. So it can be more of a flexible document where you can put in protocols to directly respond to situations that you anticipate, but even those that you can't anticipate, such as a change in relationship or a change in the law down the road. So like I said, it's something that's more comprehensive, and it's something that doesn't pass through the court process if done properly. And that is the biggest difference between the two. And if you're interested in avoiding that probate court process, then looking into a trust as a mechanism for your estate planning would be something important to do. Of course, you want to speak with an estate planning attorney in order to determine what the best strategies are for you, because it's not a one-size-fits-all. And if you're choosing a trust, there's many different types of trusts, and so it's really important that you have that conversation. If you have more questions about this, please give me a call, contact the office, be happy to assist. Otherwise, please feel free to browse and look at some of the other valuable and great information here on these videos on the page. Again, my name is Kevin Snyder, and I'm an estate planning and elder law attorney, and happy to help you.